In this case, Mr. Davison was a barrister who practiced mostly in the area of town planning. He lost his barrister's practicing certificate in 2001. Unable to practice as a barrister, Mr. Davison commenced business as a town planning consultant, providing advice in relation to town planning processes. In some but not all cases, he carefully included in his contractual documents a statement that he was not able to give legal advice. The Bar Association of New South Wales brought an action against Mr. Davison, arguing that in fact Mr. Davison was not acting as a town planning consultant at all, but rather that he was giving legal advice. They argued that merely calling himself a consultant changed nothing. It was tricky though, because it's almost inherent in town planning that any town planner is going to keep the town planning laws in mind. Any advice they give is going to be advice which is intended to comply with the law. So where does town planning stop and legal practice begin? Justice Hall said there will sometimes be no clear boundary or bright line between the work undertaken by legal practitioners and other professionals. Work may involve a number of professionals, including lawyers, who necessarily interact one with the other in the provision of advice to clients and in assisting them in disputes or proceedings. The court also found that often the term legal advice is of limited assistance. His Honour said, "The expression legal advice is a generic term that covers or applies to advice on a wide range of matters. The advice may pertain to strict legal questions, but advice provided by a barrister is not necessarily limited to technical issues of law." Ultimately, the court found that it is necessary to look at the whole circumstances and consider from those circumstances the actual nature of the work being done. His Honour said, even allowing for the fact that town planners have a knowledge of relevant law, which they bring into account as necessary, the knowledge and skill held and exercised by the defendant in the many instances detailed in this judgment was plainly not that of a town planner. It was acquired by him during his years in practice. From this case, we learn that the Legal Profession Act can't be avoided merely by putting a different label on work that is truly the work of a legal practitioner.